Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. We're talking about E-1 and E-2 visas in this set of videos. Now, there's some general considerations that you have to take into effect or that go into effect when considering to come on an E-1 or E-2. You do not need to show that you will be coming to the U.S. for a specific period of time, like with so many other types of non-immigrant visas. There just has to be an ultimate intention to depart the United States and not to permanently remain. Now, it may not be denied solely on the basis of an approved labor cert or immigrant visa petition. So even though you've applied for a green card or have that intention to ultimately apply, it can't be denied based upon that basis. You just have to have your intention that you will not reside here permanently. Basically, should the labor cert not go through or whatever the ultimate result would be. Now, the Department of State requires that you establish you will not seek adjustment of status within the United States, which is fine. I mean, you can have an approved labor cert and do everything you need to, and then consular process through your home country. Now, with the intent to return to your home residence, you do have to have some proof of foreign residence. So you can't sell everything you own in your home country in order to come here on an E1 or E2. There needs to be somewhere for you to go back. So make sure you don't put a for sale sign on everything you own before you come here. Now, each treaty, each E1 or E2 from each particular country does have little differences of their requirements. Because basically when you do the E1 or E2, you send it directly to the U.S. consulate or embassy in your home country. It doesn't need prior U.S. approval. For example, if you live in the U.K., there'll be subtle differences within the U.K. and their own little individualized requirements. So when my firm's doing an E1 or E2, we of course make sure that all of the requirements for that particular country, if there's little individualized requirements, are specified and correct in such a manner that it meets all of that country's requirements. Now, the Department of State and USCIS's regulations on the E1 and E2 are mostly the same, but there are subtle differences as well. So if you're going to do a change of status in the United States to an E2 or E1, which falls under USCIS jurisdiction, make sure, of course, that the items and the requirements are met as far as those regulations go, versus if you send it directly to the U.S. consulate overseas. Okay, more on the coming videos.